Hello, everybody. Good afternoon. We know we're the last thing standing between you and a cold adult beverage and getting towards the home stretch of the Wyoming Hackathon. My name is Bob Cornish. I'm an attorney at the Anderson Kill Law Firm in Washington, D.C. I'm part of the Wyoming Blockchain Coalition and have worked with people on various aspects of Wyoming legislation. I am a big ambassador of the state of Wyoming when I travel overseas to speak with clients in Europe and the Middle East. I am a big believer that Wyoming is going to be not only a national leader, but an international leader in blockchain. And I'm happy to be moderating this panel this afternoon on the topic of escrow, something that we take for granted in many transactions, but something that is very important in whatever it is that we're doing. And I'm happy to introduce our two speakers today that I will be handling and moderating. First is Jonathan Dunsmoor in Buffalo and Aaron Wright in New York. Hello, Jonathan. Hello, Aaron.
How are
Jonathan,
you?
doing great. Let me just let you take a moment to introduce yourself to the panel.
Thank you. Attorney Jonathan Dunsmoor, Buffalo, New York. Practicing securities lawyer who fell into this blockchain space in about 2016, late 2016. And ever since then, I've been kind of hooked, trying to figure out, what securities looks like on a blockchain, how broker dealers and transfer agents would work. And then, trying to keep people out of trouble, which is arguably a full-time job in this space. So it's been really exciting, and I look forward to, kind of what develops over the next couple of years.
Great to have you, Jonathan. Aaron, good afternoon.
Or good evening for me. Thanks so much, Bob, for agreeing to moderate this panel, and it's really great to be on it with you, Jonathan. My name's Aaron Wright. I'm a professor at Cardozo Law School. I've done quite a bit in the blockchain space. Sorry. I played a small role helping to launch Ethereum. I've worked with a whole bunch of the major teams in the space. I had the pleasure of co-authoring a book called Blockchain and the Law, The Rule of Code, which Harvard published a couple years ago, and also just write extensively about this. I also am a developer, so I've been putting together with some other folks a project called Open Law. But really happy to talk about escrow. Agree it's fundamental, kind of legal primitive that lawyers deal with quite a bit, and many business folks don't fully understand, and also think it's a key question and issue. And a lot of the tricky parts of blockchain law and regulation come down to some of these escrow-related questions or pooling-related functions. So I'm happy to dig in and looking forward to it.
Super, super. Well, let's just start with the basics for the audience. Jonathan, can you first describe to the audience what escrow is?
In its basic sense, escrow is holding funds or an asset for different parties. And so when it boils down to it, attorney escrow is overly complicated in that we have to register it with a bank and then a state. And so those assets, which most people don't know, are generally the interest is given to either an indigent defense fund or some type of legal aid, which is a fascinating element considering that it's barely any interest is derived from it. And that's one of the things that we're hopefully looking to explore and make more beneficial for indigent defense funds and legal aid as this kind of space develops and the interest rates are actually something that is appropriate.
Aaron, it's great to have a professor of law who is also involved in this emerging space. I'll pose the question to you from the basics of contract law. What are the parts of escrow that the audience ought to know about?
Yeah, I mean, I think one point to know is that an escrow relationship usually is formed via a contract of some sort, right? So parties will enter into an agreement. That agreement will basically indicate that one of the parties, that tends to be either signatory or identified in the agreement, will serve as the person that will hold the assets or funds, like Jonathan mentioned, on behalf of others. And that's a little bit different than a trust relationship, so, which is similar, right? It's a similar, and in the ballpark, a trust relationship also has a party, a trustee that has kind of a fiduciary obligation related to it. I do think when we start to think about smart contracts, a core use case and why people are so excited, and a lot of what people are doing is that they're beginning to use these code-based systems to serve, in effect, as not a party, but as a thing, a network to manage assets on behalf of others. So whenever you hear about like a non-custodial blockchain-based solution, in many ways, what they've done is eliminated the need for a party to hold some of those assets in escrow. And so these escrow relationships and or trust relationships are, in effect, what people are disintermediating, at least in kind of the early innings of blockchain technology's development. So if you're thinking about a new project or idea, maybe you should look to see where escrow agents are, or trustees in different capacities, or service providers if it's more complex pieces. They all kind of form in part a similar role.
So it sounds like to me that the use of an escrow agent is to serve as a validator of a condition precedent to release something to someone else. Aaron, would that be a fair?
Yeah, I think that is fair, right? And these types of relationships are really useful. Like think about just buying a house, right? Oftentimes an attorney will take the deposit and hold it in escrow just to know it's there, but it's not yet transferred over to the selling party, because there still needs to be an inspection and there's other kind of details that need to be worked out. So in a sense, and this is what's interesting, you can pretty much put some funds aside in a smart contract, which is pretty spectacular. And you can basically say that nobody can move it unless a couple signatures are provided, not wet signatures, but transactional signatures on a blockchain, which is pretty interesting.
Jonathan, is there a similarity between the validation that an escrow agent performs and those involved in proof of stake in blockchain solutions?
That's a really good question. Yes and no. I mean, the problem with staking, right, is that you don't always necessarily know the pool. You don't know the stakers. There's a lot of things that can be variables. And that's one of the parts of attorney escrow that we're exploring when it comes to a multi-signature wallet. Because staking, we do believe, is the future, not only from an environmental standpoint, but also a transactionality standpoint. And so looking at that as, the underlying mechanism for a multi-signature wallet kind of makes sense. But I don't think staking alone is enough to act as a quote unquote validator for an escrow account.
Aaron, any thoughts on that?
Yeah, I mean, staking is it's such a complex area. I actually have a student that's looking into some of the securities laws issues related to it this semester. So there's lots of challenges related to it. I do think kind of more pragmatically, it's how it's going to be viewed. Is it going to be viewed as a party, holding these assets and earning some sort of fees for the work that they're performing, or is it going to be viewed instead as like a profit-making endeavor? I do think that that's the kind of core inquiry, and I think it could go either way. I do think, though, even if people do view it as more of a profit-making endeavor, there's just tricky questions that we saw the SEC and other regulators try to assess, which is, even if it does potentially look like an investment contract, like what then, right? Like who's gonna be responsible for all the statutory requirements under the law? And the answer there is just not very satisfactory. So my sense is, as we sort through that, we may just get a more pragmatic answer, like we tend to get here in the US for some of these complex issues.
Yeah, Aaron, one of the things that you mentioned in your description of escrow, which suddenly rung bells in my head, was essentially the idea of basic contract law, offer, acceptance, consideration, all of those things. For those of you out there who don't know what consideration is in a contract, that's essentially the validator that makes somebody engage in a transaction to show that there's actually something behind the promise or the performance that's being offered to somebody else. Sometimes you'll read a contract and you'll see, for good and valuable consideration. And that's always a precedent, of course, for making an offer that someone can accept. Aaron, I guess the question that I have in that realm is that, are smart contracts, as we know them to be in the digital world currently, suited for these basic contractual functions, in particular, those that can be used in escrow agreements?
Yeah, I mean, we actually looked at this. There's a report that we put out looking at just the enforceability of smart contracts. That's maybe a good starting off point. But I do think blockchain-based systems, at least as they are today, they are suitable to an offer and acceptance related model. Really, in order for an individual or an entity to interact with the smart contract, at some point, there needs to be a signed transaction that that party initiates, which in many ways can be viewed as accepting some sort of agreement to enter into some relationship. And then there becomes like a secondary question, which is, okay, well, we're used to escrow related contracts to be memorialized and documented using natural language on paper documents. Can you have some sort of digital representation of that? And I think in the US, just because we take such a pragmatic approach, and also in light of the fact that we have a series of laws that implement not only electronic signatures, but also electronic contracting, which many wise people put together, in the mid to late 1990s at the dawn of the internet, that in and of itself can be considered a contract. So not all smart contracts necessarily need to be do not necessarily need to be legal contracts, but there's nothing precluding a smart contract from being considered a valid contract, particularly if all the other core pieces of what's needed to form a contract, which is usually offer and acceptance, are met. And I think you can basically apply that entire model here. And just, you don't have as much detail. Maybe you don't have as much language dealing with downside risk, which is the type of thing you would also see in an escrow related contract today.
Bonus points for everyone in Wyoming. Smart contracts are recognized as valid enforceable agreements in the state of Wyoming, so long as they have the basic elements of a contract. But reason, again, to have Wyoming law in your choice of law agreements dealing with anything digital or anything that has a smart contract. But these smart contracts, it sounds, Jonathan, that some of them are very absolute. How do you possibly address the human element of bargaining and accommodation in a world where performance would seem to be triggered by something somewhat absolute, or by unknown third parties who would be validating certain aspects of a transaction?
That's where things get really kind of offline, right? The example that we have right now with a client is they're shipping something that FedEx has to basically accept through this complicated hazardous material process. But once it's delivered, we have confirmation that it's delivered. So it's things that, can be seen in theory on a blockchain or analyzed by a bot, right? And then there's this complicated element, like we were discussing earlier. Is it actually what is supposed to be there? Is it, the actual dog food, or is it something more sinister? And the reality of it is, humans can build the smartest smart contract there is, but there's still humans involved. And so we can't, and I don't want to get derogatory, but crap in, crap out kind of thing. And that's the situation where I think, the escrow, especially for attorneys, is really important, is so that we can act as that kind of arbitrator of, I don't want to say truth, but of reality, and see, whether the certain specifics of that contract were actually met. And if they weren't, can we resolve them without having to go to court or having to threaten to sue everybody, and see if there's, some amicable way of resolving it. So the code is not the law, but the law is still the law. And I think that is something that my developer friends kind of frown upon every once in a while, but it's still a maxim that needs to be held to, especially when we start building, supply chain mechanisms that involve this kind of shipping stuff, especially internationally, because things get really weird there. But I do think that it's a mechanism that it's almost inevitable. I think anybody who understands smart contracts and what's being built recognizes their benefit and their utility. But I do think that it's something where the lawyers need to be consulted and asked, how does this work? Does this look right? Do we need to make sure that there is something written in the smart contract that says the state of Wyoming is the governing jurisdiction? And that's something that, quite frankly, most programmers, no offense out there, or developers kind of skip over, gloss over. They're so excited about what they've created that they kind of go to that legal thing last. And I don't encourage that, guys and gals. Contact us and ask before you release something too crazy in the market, because we may get a bad result from it, from the SEC, from the CFTC, from FinCEN. Something bad could happen. It doesn't necessarily always happen. I think regulators have now become more willing to, discuss certain elements of this stuff, definitely more readily. But I don't know if, just putting something out there to see if it's going to work, especially if it's something super dangerous or something that could be super dangerous, is a good idea. So just be mindful of that. Just kind of run through it in your mind.
Yeah, Aaron, it sounds like a lot of this conversation on the escrow side of things, at least in the digital context, makes a lot of sense when you're dealing with customary basic commercial transactions, such as the purchase of a home, maybe a purchase of an automobile, where you're simply holding money in escrow for the delivery of a product or a piece of real estate. How do you reconcile the function of smart contracts as they pertain to escrow in the context of more complex transactions? The first thing that comes to mind in my world are commodity forwards, for example. Somebody taking delivery of a commodity at a certain price point, or a certain delivery point, or a certain event happening. Somebody, like in oil, for example, somebody will deliver barrels of oil, and when a certain driller or operator reaches a certain level of production. What do you do? How do you evaluate those sorts of things from an academic standpoint and from a business standpoint?
Yeah, I mean, I think one thing just to recognize with smart contracts, they don't play well yet with the real world. So I think when you're examining them, you have to really look at other areas where they're being used and are being used to manage in some capacity digital assets. And I think the most interesting thing that we're seeing out of the developments in blockchain technology is that this notion, let's say like escrow, which many lawyers just take for granted, it's actually a much broader and more profound concept. And when you begin to see how people are rebuilding certain quasi-legal, / business functions using blockchain technology, you're seeing kind of its importance pop up in different ways. So escrow, as Jonathan mentioned, it's just holding an asset for somebody else. But we're seeing, as an example, lending platforms, right, where people are depositing their assets into a smart contract. So that smart contract is holding assets, for the parties that deposited in, and then other people are taking out loans. So the same very basic function, right? It's effectively an escrow-like function. It's being used to create a whole new way to perform another commercial function, right? A lending function. So maybe it doesn't yet get to some of the more complex commodities, real-world transactions that you may be intimately familiar with, Bob, and Jonathan. I imagine you may do this type of work too. But that core primitive is being used in a really, really interesting way to basically build a completely automated lending platform, right? Something that we haven't seen before. If you think about escrow too as just a concept, you begin to notice that it's popping up in a different way. And this isn't dealing with lending, it's actually dealing with organizations and funds. So there's these new organizations called DAOs that people are playing around with, where people are depositing into a smart contract. The smart contract is effectively serving as a place to store those funds that's separate and apart from each individual. So it's almost like an escrow-like relationship. And then people are making decisions on top of it and disseminating funds out to different parties. So same thing, I don't think many people would think of a fund itself as like an escrow-like relationship, but it kind of is, right? You're depositing funds to a general partner, that traditional hedge fund or venture capital fund, and then that general partner is managing that, right? They're almost acting as your escrow-related agent. So I think that's super interesting. The last area where I think escrow is coming up, which is fascinating, is around online arbitration. So we're seeing very early threads of this. But in a traditional arbitration today, the arbitrator has a lot of power to make a decision, but it doesn't have much teeth, right? It can't actually enforce that decision. So if the parties settle it up in a private arbitration, no big deal, people go on their ways. But oftentimes they don't do that because when somebody loses, they don't like to pay. So you have to walk yourself down into a court, file a separate lawsuit and enforce the arbitration decision and potentially, deal with all this post-litigation drama, which is a super pain in the butt. Most lawyers loathe it. Some lawyers specialize in it. But here you have a scenario where you can actually have the online arbitrator manage the amounts at issue, right? They can place that in escrow. And that is a pretty profound consequence. That means that the parties can actually settle their dispute, get a decision, but actually have the arbitrator, him or her theirself, deposit, the funds at issue to the other side. So those are some really, really interesting things that I think we're beginning to see just as we begin to re-examine this very, very basic concept, right? Very ancient concept of escrow. And that's why it has such a weird word. Whenever it has such a weird legal phrase, we know that it comes from either, Old England or some part of France, or maybe even further back than that. But these very basic concepts are very powerful. And I think we're seeing them being explored in lots of different ways. And I think over the longer arc, like let's say over the next 15, 20 years, we may start to see different ways for it to interact with the real world. What we built at Open Law is trying to deal with some of the issues that Jonathan mentioned. We're able to tie the best of traditional legal agreements in terms of determining a choice of law provision, choice of forum provision, representations and warranties that can be written in natural language. But at the same time, once the agreement's signed, you can actually trigger a smart contract to perform the other function. So maybe it's a hypothesis, but maybe that's what things look like in 15 to 20 years. Or maybe we just say, hey, these paper contracts are not all that great. Sorry, lawyers. We may just kind of edge you away a little bit, and or the lawyers that prepare contracts will just provide counseling and other advice, which is really never going to go away. That could be a win for everybody. I don't think many lawyers would be remiss if they didn't have to prepare contracts or change dates and all these other things. So.
Jonathan,
what Bob and I were talking about is that I would like to see a moment where lawyers actually get to be lawyers again and get to advise and help businesses and, like you said, kind of arbitrate disputes instead of correcting each other's spelling and where the commas go and things like that. One of my pet peeves is having a contract sent back with red lines that don't need to be redlined just because the attorney wants to bill out for it kind of thing. And that's, generally with some of my bigger law, no offense, Bob, colleagues. But I do think that once we're able to establish kind of the basics of contract forms, that some of the smart contract stuff can start bleeding into that. And then the lawyers can actually be lawyers again and advise their clients on how to, conduct business properly, especially cross borders. Like I said, that's the stuff that we're really looking at, because as the world expands, as we've seen with globalization because of COVID, having the right contracts and having the right parties to be able to go after should there be a dispute is really, really important.
Yeah, and I think we're starting to see that a little bit, Jonathan, too. One way that this could develop is that contracts, it's almost an evolution of the browser wrap agreement. So lots of issues with browser wrap agreements, but if you've ever prepared one as a lawyer, otherwise they kind of have the same general form, right? And it varies depending on the client, but you can bucket them out. But you could imagine a scenario where some of these smart contracts are provided on a more take it or leave it basis. We're seeing early evidence of that, right? So lawyers, particularly corporate lawyers, oftentimes will prepare the certificate, right? The stock certificate that's needed, for a company so that they can evidence ownership interest in that company. And so that's not really a contract, it's commercial paper. It's in the ballpark of a lawyer. But what the developers did was develop a standard, the ERC 20 standard. And in effect, that's what it is, right? It basically stands in place of a stock certificate in some way. Now, people may debate that because they could say it could also be used for other things. But to a certain degree, that's the case, right? A standard was formed. And now, maybe in the future, you don't need to prepare these common stock certificates anymore. You just have a token standard. Maybe you could plug in automatically or algorithmically some of the legends that may be required for various different parts of the securities law infrastructure to the extent that they're not waived. in some capacity in the future, which maybe they should be. That's a separate story. Then maybe that's the way we move forward. And maybe for your example before, Bob, where we're talking about a commodities transaction, let's assume it's a digital asset, but maybe that just becomes standardized. And we have evidence of that in the real world today, too. If you go to the Chicago Mercantile Exchange, you're not passing around these thick paper contracts between one another. Instead, members join and they sign up to rules, and those rules are represented as effective formulas, right? So, like, how much different is that than what we're talking about here with some of these agreements? So maybe that's the way it develops. I'm not quite sure yet, and that's what I think is so interesting about it. And even, Bob, it sounds like you put together lots of these escrow contracts in the past. It's a pretty standard form, right? It's not even that well drafted. It's got some gnarly language in it. Everybody still seems to use that same basic document, at least the ones that I've seen.
Right. And ultimately, when's the last time you actually talked to somebody who started bargaining and arguing about an escrow agreement?
Yeah.
Usually about the conditions that will trigger the escrow, not the escrow itself. Right.
You just grab that form, change it, and then you're on your merry way.
Right.
That's what I think we should do, is grab all the forms that we already use. The real estate forms in New York have been standardized for 10 years now. We'll just grab those and put them in a smart contract.
Yeah, I wouldn't be surprised if that's where we see it develop first. It may not be a blockchain-based smart contract, right? But we already see ISDA, which manages this massive derivatives market, push towards standardization. We've seen it in the venture capital industry with the NVCA that's really trying to standardize the documents. And what we've seen efforts to do that, it's tremendous. Now, the lawyers may not make as much money, and that's always a sad thing. Because you want to make sure that these competent people are able to to afford the lives that they deserve for the skill that they have. But you see these massive marketplaces like emerge in its place, right? If ISDA didn't exist, I doubt the derivatives industry would be as large as it is today. Now, that could be a bad thing. And 2008 is a good lesson that may not be a good thing. But overall, I think that's a positive endeavor. And to your point, Jonathan, we actually worked on the open law side with a law firm in Australia where they have standardized commercial real estate agreements, and we represented part of it in a smart contract and mimicked out what like a blockchain-based title registry could look like. And there, it takes 30 days to settle a real estate transaction. And we showed that if in this hypothetical future world, which many people envision but may not come to fruition, where everything is a digital asset in some capacity, we showed how you can settle that in about 12 seconds, right? Like you could have both parties have one party post something up into an escrow-like relationship, have the everybody that was needed to sign it, have it settled with the seller, and have the registry updated automatically, right? Like these types of things just get a lot faster. Now that's not ready for prime time, and but it just things that you can begin to think about as you begin to think about the world of smart contracts.
Yeah, it's interesting.
That's my goal, is to be able to buy something, a piece of property in a flat in London, a piece of parcel in Hong Kong or Tokyo, without having to go through the entire process. You see it, it's like Amazon. You see it, you buy it, you click it. The title registry is already done. Everything, you can have it inspected. You can all have that already kind of pre-approved and on a website. And there's people, like you said, that are working on it. And it's a weird combination of private organizations and the government. And I think that's kind of where the U.S. needs to kind of pick it up. And to Wyoming's credit, they're really working on a lot of that. But the other states, I'm really frustrated with a lot of them that we've spoken with, especially because they have a lot of talent there and they just don't see it. And then it's this complicated mechanism of, you have to teach them what blockchain is and then teach them, how to use it for this specific industry. Especially real estate. I think that's something that we can all agree that is probably a good place to start. But it's I just think real estate's hard, right? It's such an ancient system, right? We've had laws around real estate develop, for thousands of years at this point. So it's not surprising to me that we haven't moved there yet. I think what's encouraging is in this latest wave of blockchain technology development, what people call DeFi. And there's lots of regulatory issues with DeFi, so let's just put those aside. But the core mechanics of what you're seeing, it's interesting. You're starting to see things that we just couldn't do before, and I think that's where people get
more fascinated. So you could look at the development in blockchain tech, from 2009 to really 2016 is the core protocol. And then you saw the first use case, these token sales for ICOs, and that was crowdfunding, if you generalize it. And crowdfunding has existed in different capacities and different flavors for a number of years. But when you look at some things that are happening in the DeFi ecosystem, you're just seeing brand new stuff, being able to create a marketplace where you don't have an order book. What? We've had order books on marketplaces probably since there was shady traders under the buttonwood tree in downtown Manhattan. So there's new ways to start doing things, and that's where I think we'll start to see more interest, and that's also why I think regulators will start to take a more pragmatic approach here. I mean, I think Wyoming is a great example here, where there's strong beliefs in making sure that people can privately order their affairs using contracts. This is, I think, a uniquely American thing to place so much emphasis on contract law, and I think it's actually one of the wisest and hugest competitive advantages that the U.S. has. And I think that's being explored really in depth in Wyoming, and also in depth in the blockchain ecosystem. So I'm still optimistic. There's definitely tons of really tricky stuff. Nobody wants to see consumers get hurt, but I do think we're starting to see some real innovation, probably for the first substantive time. That's not just somebody talking on a panel about it or something like that.
I'm going to throw this out, considering all three of us are barred in the state of New York. If you're engaged in a digital transaction that may have an escrow element to it, or an indenture trustee element to it, such as municipal debt or corporate debt, given the state of affairs right now, wouldn't it make sense in a swap or a bond to have Wyoming law control that transaction rather than New York at this point?
Absolutely.
If there's digital assets involved, I think that it's beginning to be the case. I guess the only countervailing weight would be if you had a counterparty that had more leverage, that would just mandate that New York law applies, right? So,
assuming that the counterparty will agree to it, but wouldn't it make more sense, given the recognition of smart contracts and all the digital protections that we have in Wyoming, that if we were engaging in a smart contract transaction that was complex, say a swap or a real estate transaction, wouldn't the regularity of Wyoming's blockchain and digital laws make more sense than the convoluted things that we have in New York?
Absolutely. I mean, I think that's where the states need to, like I said, get involved. Is their inability to recognize this is really frustrating. To take, the entire county's deeds and put it on a blockchain, I think is something that is eventually going to happen. And the first title insurance company that gets that is really going to start to be able to control an entire marketplace. But it's going to need the state to play along. And if that has to use Wyoming law to be the foundation of that, then so be it. But I don't know, from the financial side of things, I would love for the debt markets to become more regulated, and I do think that they should choose Wyoming. But once again, it's this weird combination of public and private markets that need to play well together, and we'll see. I mean, that's the challenge to everyone listening, is if you're developing something like this, try to develop it out and contrast it with Wyoming law, and speak to one of us or someone who's familiar with this, so we can really start developing it within the states. And if Wyoming becomes the de facto state, that's fine. That's great, because it gives us the same way other states have led in various ways. It gives us the ability to kind of base the entire model off of one state who's doing it really well. But this does need to spread. This can't only be a Wyoming thing, or we're in a lot of trouble.
Well, the Chancery Court creation in Wyoming is definitely going to help with the imposition of Delaware precedent. I think that would definitely help a lot of the naysayers on the corporate side. But Aaron, being in Manhattan, I'm certain you'd be aware of the institutional inertia that would take place with AmLaw 100 law firms doing complex transactions to suddenly turn off the New York law switch and turn on Wyoming. How do we deal with as innovators in this industry, and how do we get people to take advantage of all these great things we have in the state of Wyoming?
One I think that's 1,000% right. And, you know, maybe one way to think about it actually goes back to crowdfunding. So we did see crowdfunding laws start at the state level, and they started in Washington state, if I'm not mistaken, and maybe Colorado. But some early states, particularly Western states, were willing to roll the dice and basically say, if you are doing crowdfunding in the state, obviously they had authority to, you know, and jurisdiction to basically mandate that, they allowed these types of mechanics to begin. And then people realize, hey, this is not as risky as we thought. And that tends to be the case, right? We get a little bit worried, particularly lawyers, especially regulators, that something bad is going to happen. Almost like when you see your kid going really fast on a bike, and then, but sometimes what happens is you're like, oh, he's okay, right? He didn't fall, and it's all going to be fine. And I think that, and I'm hoping that over the next couple of years, as we see more and more blockchain-specific industries, like the speedy banks that we're seeing chartered, et cetera, that people get more comfortable with digital assets. And the moment that that's the case, my sense is that other major jurisdictions, and not just New York, but let's also talk about London, right, which also has a major foothold here for international purposes. I think they'll begin to accommodate their laws so that they can get the upside. I think it's a truism that New York does not leave money on the table. So, so if there's money to be made, I have a feeling that we'll still have awfully horrible laws that implement that, but we will make sure that there's an opportunity for people to do that in a responsible way. And I think you're also seeing that, right? If you look at the New York AG's approach, they're really focused on marketplaces and building the safest marketplace. You know, I think America has like the New York Yankees of marketplaces. They're safe, they're professional, they tend to win. And my sense is New York recognizes that when it comes to digital marketplaces and making sure that the digital marketplaces licensed in New York are safe, et cetera, in the long run should win. And I imagine the same answers will happen with custody, which is, I think, a big blocker in New York right now, right? Like, how do you custody these assets in different ways?
You talk to most lawyers who are in New York, of course, the selling point that always comes up about New York law is that there is no private right of action under New York securities laws, right?
Yeah.
It's the only state in the country, frankly, that has virtually a blanket ban on private litigation under state securities laws, not federal, but state.
Right.
Is that enough of a selling point, you know, to choose New York over Wyoming for, you know, if I were engaged in a digital bond transaction with of an issue of international scope of millions of dollars, would that make a difference in your mind, Jonathan? Aaron, we only have 2 minutes left, by the way, so quickly.
Time flies. I don't know, honestly. I think it could. You know, we're looking at some complicated bonds for things like PPE and weird digital assets, but I don't know. The marketplace is a very, very weird thing, and I'm a firm believer of letting market forces determine what the market wants. I don't believe in building something and seeing if the market wants it. So I think that it's going to be something, as Aaron's kind of hinted at, that we've got to play around with it and see what works. But if Wyoming continues to develop out, you know, the process of law that makes it safer for investors to participate in a market, I think that it's going to be more likely that they choose that law. And especially when it comes to these weird DeFi solutions and other alternative assets that are being developed, you know, the sky is basically the limit. And so we've got to protect our people, and we've got to protect investors as much as we can.
Yeah, and I think the answer depends, Bob, and I'm going to give you the classic lawyer answers. It's going to depend, but I will say, you know, outside of New York, lots of contracts also designate Delaware law, right? Just because it's at least at this point in time, the cradle of corporate law in the U.S. But let's not forget the history of corporate law. I mean, the state chartered corporation started in New York, right, around 1811, gravitated down to New Jersey, and then Delaware basically took it from New Jersey. So the beautiful thing about the U.S. is that it really is a laboratory of states. We get to compete in different ways and see which laws win out. So in the long run, if Wyoming's laws truly are superior and the market judges it as such, and I think that there's a great argument, at least now, that we're far along that path, then maybe, you know, the next lawyers, when, you know, I'm old and gray and retired and hopefully in a warm, sunny place, will be designating Wyoming law instead of Delaware law, or something along those lines. I think that's completely feasible.
Well, we're going to be winding up our presentation here, but I think the one takeaway you have definitely in the area of escrow here is that Wyoming offers a sound basis to use it as a choice for your choice of law in escrow, and especially if you're dealing with anything digital, it just makes sense given the UCC provisions that we have and other things in place in the state. You know, the municipal debt function that the legislature passed, of course, is going to be an interesting one to see how that develops, I think, in the next coming years. But I think we're going to be opening this up to questions, and once once we hear from the audience, we'll wrap things up and let you get back to the hackathon. Do we have any questions? Okay. Well, I apologize for that. I don't have the VR site handy on my computer at the moment, but anyone who wishes to pose a question to any of us, please reach out to us directly. We'd be happy to answer any questions you might have in terms of escrow, the particularities of escrow. We didn't get into a lot of the issues in terms of you know, some of the basic contractual clauses that you see in escrow agreements. And regrettably, I didn't get to talk about my legal hypothetical that I wanted to pose to our two speakers today, was Saul Goodman shipping oil to the Czech Republic and being involved with Walter White. You know, what function would digital escrow have in that arrangement to protect the ultimate end user of that oil? Just a thought question to think about when you leave. How do you apply what you know about escrow and digital and digital assets and blockchain and smart contracts, and how do you apply them to transactions that may well be troublesome? Take that away, think about it. Jonathan, Aaron, thank you so much for your participation today. It's been great having this conversation. And everyone else, please enjoy the hackathon and your time in Wyoming.
Thank you.